Hello, good afternoon. Good afternoon, students. We are going to have a lecture on the invalidity of juristic acts. Okay, so we are going to start in a few moments. Hello, hello, hello. Okay, hello again. Welcome back to our class. Okay, this morning we have seen the nature, the meanings, and essential elements of a juristic act. Okay, which is something laid down by law in section 149 of the Civil and Commercial Code of Thailand. Okay, I hope that you have clear understandings of that. Okay. So this afternoon we are going to move on to consider uh, invalidity of juristic acts. Okay, sometimes when a juristic act is made, it does not mean that that juristic act will have the full legal effects. Sometimes a juristic act in question may become void or may become voidable. Okay, there are some factors which render a juristic act in question to be invalid. Okay, so the important word here is invalid. Okay, or the invalidity. Okay, that is in Thai we use the word ความไม่สมบูรณ์ okay, invalidity of juristic acts. Okay, so this is what we are going to discuss in this afternoon. Okay, I hope that you can remember from a discussion this morning. Okay, that there are four elements. Okay, of a juristic acts. Okay, there are four essential elements of a juristic act. Okay, the first one is an act in the form of the declaration of an intention. Okay, and the second one is lawfulness. Okay, the act in question must be lawful, and the third one is voluntariness. The act in question must be a product of voluntariness. The person who makes a juristic act must not be under threats, duress, or some factors which vitiates the will of the party. Okay, and the final crucial element, the final essential elements of a juristic act is the purpose or purposefulness of a juristic act. Okay, the juristic act in question must be done for a particular purpose. In fact, it is for establishing legal relations, okay, with the will to creating rights, okay, modifying rights, and transferring rights, preserving rights, or extinguishing rights. Okay, this is what we have discussed this morning. Okay, so as I have mentioned, okay, that sometimes a juristic act in question may become invalid. Okay, that there are in fact some factors or some causes of invalidity. Okay, a juristic act may become invalid because of some factors or because of some causes. Okay, there are 1, 2, 3, 4 here. Okay, 1, 2, 3, 4 principal causes of invalidity. Okay, the first one, the first cause. Okay, the first cause of invalidity. It is the lack of legal capacity. That means that the person who makes a juristic act may not have the capacity as required by law. Okay, a person need to, in order to do something, in order to make a juristic act, okay, a person need to have legal capacity. Okay, some persons may not have any legal capacity at all. Okay, some persons may have limited legal capacity. Okay, and okay, if a person does not have capacity and go ahead with the conclusion of a juristic act, that juristic act may become invalid. Okay, that is the first cause of invalidity. The second cause of invalidity rests upon the object. Okay, the object is in fact the purpose. Okay, an object or objects of a juristic act may be the improper. Okay, so the law requires that an object of a juristic act to be proper. Okay, we will talk about that later. The third reason, okay, or the third cause, the third reason for invalidity, or the third cause of invalidity lies in the failure to comply with the form prescribed by law. Okay, some juristic acts may be required by law to comply with legal forms. Okay, so if the law says that when this, for instance, contract, okay, needs to be in writing, and a person makes that contract without the making it in writing, that means that that person that makes the juristic act, okay, in the derogation from the legal requirement as to the form, so that that juristic act will not be given legal effect. Okay, so we will see that later. The final cause of invalidity rests upon the impropriety or vitiation of will. Okay, maybe the will of the party, okay, is vitiated, okay, for some reason. Okay, so when the will of the party is vitiated, okay, then that juristic act may not be given legal effect. Okay, so we will explore, okay, these causes of invalidity, okay, in turn, beginning with the first one. The first one should be something not very complicated, okay, because I believe that in last term, okay, in the last semester, you have taken a course, okay, on the introduction to law, something like that. Okay, so I hope that you have been introduced in the legal capacity. Okay, so that this is something which is also linked to the conclusion of a juristic act. Okay, so we will explore, okay, that is cause of invalidity at great lengths, okay, right now. Okay, so you can see that when some persons may not have any legal capacity at all. Okay, so when a person has no legal capacity at all, that means that that person cannot make any juristic act, because the law, okay, the law does not give that person any legal capacity. Okay, but sometimes a person may have limited capacity. It means that he or she has legal capacity to do something, but he or she may not be allowed by law, to make juristic acts. Okay, in some cases. So that means his or her capacity is simply limited. Okay, when we talk about the capacity or legal capacity, okay, of a person's capacity for the conclusion of a juristic act, okay, we will talk about the case of first a minor, okay, and the second case is the case of a person of unsound mind. Okay, so a person of unsound mind, or in Thai, kon vikoncharit. Okay, and the third one, it is the quasi incompetent person. Okay, we call this one the บุคคลเสมือนไร้ความสามารถ. Okay, this is different from a person of unsound mind. Okay, if somebody is of unsound mind, okay, that person may be adjudged by the court as an incompetent person. Okay, so these are the three main the persons, okay, in respect of which the law says something about legal capacity. We will first look at the case of a minor. Okay, a minor, or in Thai, ผู้เยาว์. Okay, you should be mindful. You should remember, okay, that you should recall that a minor is a person who has not yet become sui juris. Okay, the person who has not become sui juris, okay, in this country. Okay, that if you are below 20, then you are still minor. Okay, you will become sui juris upon completion of the age of 20. Okay, sui juris is what บรรลุนิติภาวะ in Thai. Okay, if you become sui juris, that means that you have full capacity. But if you are not yet sui juris, okay, you are a minor, then the law restricts in your capacity. Okay, the law says something about your capacity. Okay, as we should be well aware, when somebody is a minor, that means that he or she does not have, sort of enough care. So that's why the law places minor under care of whom? Under care of the legal representative. Okay, so every minor will have legal representative. Okay, or in Thai ผู้แทนโดยชอบธรรม. Okay, legal representative. Okay, so who is the legal representative of the minor? If you look at, okay, first of all, we will look at section 21 first, which is provision of law which say that a minor needs to a minor can just make a juristic act, okay, upon consent of his legal representative, okay. So otherwise, the juristic act in question will become voidable. That means let's say that if a minor, if A is a minor and A makes the contract with B, okay, without A's legal representative, then that the contract will be voidable, okay, it will be voidable. Okay, so that when it is voidable, it will have some legal effects or legal consequences. We are not going to talk about legal consequences of a voidable act in this session, okay, maybe in the next session, okay. Today, we will just discuss the legal capacity of some persons, okay. So we are now talking about the case of a minor. As I have mentioned, a minor, because the law realizes that a minor seems to be careless or the minor seems to lack care, okay, so that the law does not want a minor to make a juristic act, okay, in his own volition, okay, without consent of parents or without consent of legal representative, okay. So that's why Section 21 provides as follows. If you look at Section 21 of the CCC, okay, a minor may make any juristic act upon prior consent of his legal representative, okay. Any act carried out by a minor without such consent is voidable unless otherwise provided, okay. So that is clear that in order for a minor, okay, to be able to make a juristic act, a minor need to obtain consent from his legal representative, okay. So the question now is, who is a minor's representative? If you look at family laws of this country, of course, family law in this country, it is contained in Book 5 of the Civil and Commercial Code, okay. If you consult Section 1569 and 1566, then you will have an answer as to who is a minor's representative, okay. So the thing is that a minor, the one who is a minor representative, it is the one who exercises the parental power, okay. Then who then exercise, the parental power over a minor? The answer is that in the case of a minor, it is the parents. So to put simply, if a minor has parents, then a minor needs to get consent of his or her parents for the conclusion of a juristic act. Otherwise, that juristic act will become voidable. Okay, so this is the rule. Okay, so when we have seen the rule that a minor can make a juristic act only upon consent of his parents as his legal representative, we will next ask the question, okay, is there or are there some exceptions? The answer should be yes, right? The answer should be in the affirmative, okay. So even though the rule is that a minor need to get consent, okay, from the parents, if the minor needs to make a juristic act, right? Let's say that a minor want to buy this car. Okay, so if the minor wants to buy the car, let's say that the minor is rich enough, a minor, some of you here in this class may still, become a minor because you have not yet attained the age of 20. Okay, some of you here are perhaps 18 or 19. Okay, or some of you here will be 20 of age. 20 years of age. That maybe in a few months' time. Okay. I believe that many of you here are still minor, maybe you are 19, okay? So let's say that you are so rich. You have, let's say that 10 million baht at the bank account, okay, and you are interested in this car. If you want to buy this car, then you need to get consent from your parents, okay? If your parents say, yes, go for it, go for this car, then you can buy this car. If you have not secured the consent from your parents as your legal representatives, then that means this contract of sale will simply become voidable. Okay, so you have to make sure, as I have mentioned, okay, there are exceptions. Okay, If the law always requires a minor to obtain consents from his parents as the legal representatives, then it will cause sort of inconvenience, because in some transactions the need to be flexible, okay, for some reason, okay. So that's why the law provides for some exceptions, okay, to the rule that a minor gets consent from his legal representative. That means that in some exceptional cases, the law allows a minor to make a juristic act, okay, without even getting consent from legal representatives of the minor at all, okay. So the law, in fact, the CCC, okay, lays down a few cases, okay. According to section 22, 224, and section 27, okay. We will look at these exceptions, okay, in turn, okay. The first one, it is this one, okay. If a minor, the first one is that if a minor wants to enter into a juristic act, okay, under which the minor merely acquires a right, or under which a minor is discharged, from a particular duty. In this case, if the minor merely acquires rights, okay, or the minor is merely discharged from a particular duty, that means that in that transaction, in that juristic act, a minor has nothing to lose. The minor just, has benefits from the juristic act in question, or the minor is just discharged from, the duty, right? So in this case, there is no harm. Obviously, there is no harm to the minor. That is why the law says that in such a case, a minor does not need to get consent from his the legal representatives, i.e., his parents, in the general. Okay, so now I have two examples for you. The example number 1 and example number 2. Okay, in the example number 1, okay, a juristic act under which a minor merely acquires a right. It is in the case of receiving a gift which is not encumbered with any charge. The gift which is not encumbered with a charge, or in Thai we call this one การให้โดยไม่มีค่าภาระติดพัน Okay, let's have a look at this picture. For your understanding, okay. Let's suppose that we have the Mr. Bean. On this slide, okay. Mr. Bean is very generous, and he wants to give this car, his car, Mr. Bean's car, okay, as a present to a boy here, okay. Let's say that this boy is 15 years of age. Okay, so when Mr. Bean wants to give this car to this 15-year-old boy, does the 15-year-old boy need to obtain consent from his parents? The answer is no, because in this transaction, in this juristic act, this minor has nothing to lose. Okay, it is the case of a gift not encumbered with a charge. So when it is a gift not encumbered with a charge, okay, the minor merely obtains something. Okay, the minor merely acquires a right without losing anything. So obviously, there is no harm to the minor at all. That's why, according to section 22, in this case, okay, a minor may carry out any act if it is merely for the purpose of acquiring any particular rights. See, so that this is quite clear, okay? Or so in some cases, okay, a juristic act in question, okay, does not cause any harm to a minor. In that, okay, the minor will simply be discharged from a particular duty without, without having any grievance at all. Okay, so in this case, the law, section 22, also say that a minor may go for it. Okay, a minor may just conclude this juristic act, okay, without getting consent from the legal representatives. Okay, so if you look at the second part of section 22, I try to reread, okay, the wording in 22. A minor may carry out any act if Okay, it is merely for the purpose of acquiring any particular right or for the purpose of being discharged from any particular duty. We are going to look at this example. Let's say that we have in this case the Nobita, okay, and the Giant, okay. So let's say that Giant here, he has a car, and he he was scheduled to go to the UK for his own education. Let's say that he would have to go to Cambridge to study law. Okay, so he asked Nobita, okay, to keep his car for a year during his education pursuit. Okay, so when he came back to Thailand, okay, he asked Nobita to return the car to him. Okay, so when Nobita, okay, want to return the car to the Giant in this case, does Nobita need to get consent from his parents? The answer is no. Okay, because in this Juristic Act, it is obvious that the return of the property back to the return of the property to whom? To the depositee. Depositee is what? Depositor. Okay, ผู้ฝากทรัพย์. Okay, when the one who to keep the car for somebody else, the one who keep things for somebody else, we call that one depositee, ผู้รับฝาก. Okay, when the depositee return property to the depositor, you can see that in this case, the depositee will simply be discharged from the duty to keep the property. Okay, so when the minor in this case is just discharged from this duty, okay, there is no harm at all to the minor because the minor is simply discharged from the duty. So in this case, section 22 say that the minor does not need to get consent from his legal representative or parents in this case. Okay, so it seems to be quite clear. The reason behind the law seems to be clear. Okay, so now we are going to move on to see the next exception. The exception is the next exception is this one. A minor may enter into a Juristic Act without consent from his legal representative if that Juristic Act it is something strictly personal. Okay, something that's strictly personal. That means that it is concerned with the personal affairs. Okay, so it does not need consent from the legal representative. Okay, let's suppose that before going to example, let's have a look at what the law say. Okay, the law sets out this exception in section 23 of the Civil and Commercial Code. Okay, section 23 provides as follows: a minor may carry out any act which is simpliciter personal. Simpliciter is a Latin word that means simply. Okay, a minor may carry out any act which is simpliciter personal. Okay, something which is personal. Then if you are a minor and you want to carry out a Juristic Act which is strictly personal, then you don't need to get consent from your own parents. Okay, let's have a look at an example. The example number one, it is the legitimation of a child. Okay, or in Thai, รับเด็กเป็นบุตร. Okay, let's suppose that in order to enable your understanding, let's have a look at this slide. Let's say that we have Alex and Betty. Alex is the male, the person, and Betty is a female person. Okay, so let's suppose that Alex is still a minor. Let's say that in this case, Alex is 19. Okay, Alex is 19, and Alex and Betty they cohabit. Okay, they are not husband and wife simply because they are unmarried. In order for the A and B to be husband and wife, okay, they have to register their marriage. In this case, okay, Alex and Betty just live together as husband and wife. They live together, they cohabit, okay, without without affecting any registration of the marriage. So they are not husband and wife, okay, according to the law. Okay, they are just cohabitees. Okay, so what the law says is this. Okay, if two person, the male and the female, if they live together, okay, without becoming husband and wife, okay, if they have a child, that child will have the status as what? The status of that child, it is just an illegitimate child. Okay, so a child born, okay, the child born is just an illegitimate child, okay, but no good mind. Okay, so that's mean that Alex in this case is not the legal father, and the child here, it is not the son. It is not Alex's son. Okay, according to the law, right? So the law say this. The law say, well, if you are Alex here, if you are Alex and you want this son, the illegitimate son, to become your legal son or to become your legitimate son, then there are some ways. There are in fact three ways. Okay, you will study this, maybe in your the third year, okay, in family law. In order to convert the status of a child from the illegitimacy status into the legitimacy status, the law say that you need to do one of these three things here. The first one is that A and B, Alex and Betty here, will marry later. Okay, at the time when the child was born, of course, Alex and Betty, were not married. But if later Alex and Betty are married, fine. Okay, when Alex and Betty are married later, then that son, that child will be converted into into what? Into a legitimate child. Right. So this is the first channel. The second channel for conversion is to effect registration of child legitimation จดทะเบียนรับเด็กเป็นบุตร Okay, so Alex needs to, affect the registration of child legitimation. Okay, the third channel is to go to court in order to get judgment of the court, pronouncing Alex as the father and pronouncing, the son as the legitimate son, right? So in this case, let's suppose that Alex chooses the second way, registration of child legitimation. Okay, in this case, if Alex want to effect registration of child legitimation, does Alex need to get consent from Alex's parents? Because Alex is now, still 19-year-old. Okay, if Alex want to acknowledge that this son is his own son, Alex wants to acknowledge that through the registration of child legitimation. In this case, the law regards this matter as something strictly personal, so that Alex does not need to get consent from his own parents. Alex can go ahead with the registration of child legitimation. Okay, this is a very very striking example. Okay, the second example, it is the execution of a will. Okay, so let's say that that Alex, who is again 19-year-old, he has a lot of property. Okay, he is very rich, and he has some fear that he is going to die very soon because probably he has a very appalling health. Okay, so that he wants to execute a will, ทำพินัยกรรม Okay, he wants to execute a will, bequeathing his property to some persons. So in this case, if Alex wants to execute a will, does Alex needs to get consent from his own parents? The law regard that execution of a will, it is also something which is personal, something which is personal. So in this case, Alex does not need to get consent from the parents. Okay, this is an exception embodied in section 23. Okay, but with respect to the execution of a will, you need to be mindful as well that the law set the age, the minimum age for a person to be able to execute a will. The person must be of at least 20 years of age, otherwise the will become void. Okay, so that is one thing to be borne in mind. Okay, Now we are going to look at the exception number 3. Even though the rule is that a minor needs to get consent from his legal representatives in order to make juristic acts, but the third exception it is this. Okay, it is this: a minor may carry out any juristic act which is suitable to the minor condition in life. In Thai we call this one สมแก่ฐานานุรูป. Okay, that means that is something necessary. A minor may enter into a juristic act which is suitable to his or her own condition in life and actually necessary for his reasonable living. You can imagine that. Let's say that when you are now 19. Okay, you are now 19. Pinai is now 19, and Pinai, while he is at the university, okay, while he is on campus, he want to buy lunch, he want to buy dinner, he want to buy breakfast, okay, he want to take a bus, he want to take a shuttle bus, okay, within the campus. Let's say that the bus, the collect money, okay, he need to just enter into the contract of carriage. In these cases, doesn't mean that you as a minor, if you are 19 years of age, doesn't mean that you need to make a phone call to your mom and dad. Mom, dad, now I'm going to buy lunch. I'm going to buy a hamburger. I'm going to buy the fried chicken, KFC fried chicken. Please, mom and dad, please give me consent. Will you need to do so? You can see that it's so weird if the law requires you to do so, because this is something necessary. This is something very suitable to your condition in life, and this is something actually necessary for your own living. So in this kind of case, in such a case, you don't need to get consent from your parents as legal representatives. Okay, it is an exception provided by law in section 24. Okay, if you come back to look at section 24, it says a minor may carry out any act which is suitable to his conditions in life and necessary for his reasonable living. So the reason behind these provisions of law seem to be clear cut. Okay. Now we are coming to we are moving on to the exception number 4. Okay. In the exception number 4, this is concerned with a juristic act which is done in connection with the operation of business or the employment. Okay, when the legal representatives of the minor has previously given permission to the minor to carry out that business or to enter into employment as an employee. Yeah, I'll give you this example. Okay, let's suppose that you are so smart. I'm going to give you example first, and then after this we are going to look at what the law says. Okay, because this example seems to be very, very simple, and that will help you very much in understanding the law. Okay, let's suppose that this is a child. Let's suppose that this child is smart. He is very much talented in business. Okay, he is talented in the motorbike repair. Everybody in these areas knows of his reputation, knows of his reputation in motorbike repair. So in this case, he wants to set up the business, the family business. Okay, the business of motorbike repair. The parents, his own parents, also realize his talent. And the parents say, well, son, fine. We know that you are very, very talented, very gifted in motorbike repair. So you can set up the business, the motorbike repair business. You can just set up your own garage. Okay, because you are talented enough. We give you permission to operate this business. You can see that when the parents see that the son is talented this way and gives permission to the son for the operation of the business like this, that means that the parents trust the son. Okay, so when the parents already placed the trust in the son, right? The law say that, well, when the son is talented, okay, the son should be treated as what? As an adult. The son should be treated as the person who has attained the legal age, okay, of maturity, because he is so talented and the parents already gives him permission to run the business like this. So if he make juristic acts in the course or in connection with his business as permitted by the parents, he does not need to get consent from the parents. Okay. So when this son operates his business, in this case, this mobile repair shop, this son can rent a small building, okay, to be used as the premises for this garage. Fine. The son can rent a small building without having to obtain consent from the parents first. The son can even draw checks for making payments in his business. Right, so this is this is an exception. Okay, now we come to see what the law says. Okay, the law lays down this exception indeed in section 27. Okay, in section 27 of the CCC. Section 27 of the CCC provides as follows: the legal representative may give a minor consent to the operation of commercial business or other business, or to the conclusion of a contract of employment for becoming an employee thereunder. Okay, and the law says what? Okay, in paragraph 2 of the same provision of the same section 27, paragraph 2 says further, in connection with the operation of business, in connection with the operation of business or the employment under paragraph 1, okay, in connection with the operation of business or the employment under paragraph 1, okay, a minor shall be treated in the position, okay, a minor shall be treated in the position as if he has become sui juris, even though at that time the minor has not become sui juris yet, because he is still 19 and he is not married. Okay, if he is 19 and he is married, the law says he will become sui juris. Let's suppose that this boy, he is still 19 and he is unmarried, so he is still minor. Okay. But the parents give him permission to run this business. When the parents gives him permission to run, the mobile repair business, in connection with this business, he can do everything. Okay, he can enter into any juristic act without getting consent from his own parents. Okay, one more example. Let's suppose that these are the parents, and the parents has a son, in fact, a kid. The kid. This kid, let's suppose that he is just 15, and he looks what? He looks something like 14 or 15. On this picture, okay. But he is very gifted in acting. Okay, that when he is very talented in acting, right? Some movie makers contact him so that he will become the star. He will become the star in some movies, in some films. Okay, he can just play the role of let's say that of this the legendary story Gomin in this case. Okay, so in this case he signed a contract. He signed a contract with the filmmaker upon permission of his parents. So the parents have given him a green light to sign contract of employment as an employee, he is a filmmaker employee. Okay, so in this case, let's suppose that after that, the filmmaker sends him a list of movies for him to choose. Okay, let's say that there are some movies, and the filmmaker wants him to choose which movie he prefers to act in. Right. So when he makes the selection of the movies listed in this list, does he need to get consent from the parents? Okay, let's suppose that after he makes selection of the movies, let's suppose that the contract of employment requires him to do so. This is the duty under the contract. Okay, the contract requires him to make selection of the movies from the list, okay, to be sent to him by the movie maker. Of course, this is a juristic act because it will carry some legal effects. It is something, okay, to be performed, under the contract, right? So it is in a way a juristic act, right? So in this case, does he need to, make a phone call to his parents to say, well, mom and dad, I want to, choose these movies, okay, in order to perform my obligations under this contract, right? Does he need to do so? Does he need to make a phone call to his parents? The answer is no. Because the parents trust him already, okay? The parents allows him to sign a contract, okay, for becoming an employee. Okay. So in connection with this contract, okay, he can just do everything. He can just agree on the list of movies. He can just even rent a small room for resting after the film shooting. Let's say that after the shooting, after the filming, he seemed to be tired. He does not want to go home. He wants to rent a small room, okay, just near the studio. In that case, the room is quite small like this, okay, and it does not incur him a lot of money. Does he need to to make a phone call to his parents in order to get consent from his parents? Right. In this case, he does not need to do so. Of course, he can again rely on Section 27. Remember, Section 27 just talk about two situations. Okay, situation. The first one, as we have discussed, okay, is that the legal representative has given consent to the operation of commercial business or other business. Okay, this is the first one. The second one is this. See, you see the word "or." Okay, the second one is that the legal representative has given the minor consent to the conclusion of a contract of employment for becoming an employee. So in this case, that now this boy is a filmmaker employee. So that in this case, if he want to select, okay, the movies from the list of movies, if he want to rent a small room for resting after the filming, he does not need to get consent from his own parents. These activities fall within the scope of exceptions as provided by law. Right. That is the first case. Right. Now we are coming to the second type person. The second type of person to be in respect of which the law also the takeaway on the law sets restrictions on the legal capacity is a person of unsound mind. คนวิกลจริต. Okay, before having further discussion, I think that please allow me to go and have a look at the screen, okay, in order to make sure that the video which I'm which I am recording now, okay, the lecture which I'm recording now is fine. The video facilities seem to be fine, okay, in order to prevent from some mishaps. Okay, let's have a look. Okay, now I have a look at the first device, which is the tablet, okay, Galaxy tablet. It seems to be fine, okay. according to the screen, okay, 44 minutes have passed. And according to the iPhone, hello. I also, just establish another device, the other device, which is the iPhone, okay, to do the recording. Two devices at the same time to make sure that the recordings seem to be working well, right? Okay, I think that so far so good. When nothing happens in terms of technical problems, okay, there is no technical problem, so that I think that we are going to go on to we are going to carry out the lecture, right? We are going to continue the lecture right now. Okay, thank you very much for your attention. Thank you. I'm going back to my desk. Okay, good. Okay, we have look at the case of a minor, and we have seen that the law places a minor under care of the legal representative. A minor may not enter into a juristic act unless the minor get consent from his legal representative. Okay, but there are some exceptions. Okay, so with respect to the second type of person, i.e. a person of unsound mind or in Thai คนวิกลจริต this is even more obvious that this person requires protection by law. When a person becomes when he becomes out of his mind is now unsound. Maybe he has something so serious. He is upset about something, okay, and he seemed to turn into a crazy man, okay. He turns into a crazy man like this. When I say a crazy man, it doesn't mean that you are crazy for a while, okay. Your mind is something like your mind. You just mean that you are just out of your mind. Your mind is now unsound. You don't even know what you're doing now. You don't even understand anything. You don't understand anything. A person of unsound mind does not understand anything. Okay, he is totally unable to perceive things. Right. So in this case, the law just protects him by doing what? The law say that in this case, this person may be adjudged as an incompetent person. An incompetent person is called คนไร้ความสามารถ in Thai. Okay, so if somebody is a person of unsound mind, that person may be adjudged by the court as an incompetent person. Okay. When somebody is adjudged by the court as an incompetent person, he does not have any legal capacity for the obvious reason that he does not understand anything at all, so that in this case the law will place him under care of whom? Under care of his, the law call this one guardian. Okay, guardian, the ผู้อนุบาล in Thai. Okay, guardian. Right. He is placed under guardianship, or in Thai ความอนุบาล. Right. So obviously, when this person does not understand anything at all, his mind is totally unsound. The law does not allow this person to carry out any juristic act. Everything needs to be carried out by the guardian. Right. So there is no such thing as getting consent. There is no such thing as requiring consent from anyone, because he cannot understand things at all, so that it is his or her guardian who just does or performs everything for a person of unsound mind who is adjudged as an incompetent person. Okay, this is according to the section 28. Okay, in fact, section 28 paragraph 1 says that any person of unsound mind may be adjudged by the court as an incompetent person. Of course, the procedure for bringing the motion, okay, bring the case before the court in order to adjudge a person of unsound mind as an incompetent person. Okay, this is a detailed procedure. Okay, so the person who can file an application to the court is the spouse, the ascendant, the descendant, okay, or the curate, or the what, the guardian, the curator. Okay, maybe you don't need to pay attention to this one. Okay, what I'm saying is just that. Okay, when a person is of unsound mind, there is a procedure for bringing the case before the court in order for the court to adjudge the person as an incompetent person. When that person becomes an incompetent person, then that person will be placed under care of the guardian. He is under guardianship. Okay, so that the guardian will do everything for him. He has no capacity to do anything at all. Okay, Section 28, paragraph 2 says that a person adjudged by the court as an incompetent person under paragraph 1 shall be placed under guardianship. Okay, the appointment of the guardian, powers and duties of a guardian, or termination of guardianship shall be in accordance with the provisions of Book 5 of this code. Book 5 of this code, the embodies family law of Thailand. Book 5 of the code, it contains provisions regarding the guardianship and the guardian, everything about the guardianship and the guardian. Okay, so when a person is placed, when an incompetent person is placed under care of the guardian, right, then the guardian will do everything for him. What happens if an incompetent person just makes a juristic act? Okay, the law say that everything must be done by the guardian. But if the person, if a person who is adjudged by the court as an incompetent person carries out a juristic act, what is the legal consequence of that juristic act? In this case, Section 29 says that juristic act will be voidable. Say 29, Section 29 provides as follows: any act carried out by a person adjudged by the court as an incompetent person is voidable. Okay, so the act is voidable. The consequences of voidability will be discussed maybe next week. Okay, you don't need to pay attention to the legal consequences of the legal consequences of voidability right now. You should just be mindful that that if a person of unsound mind who has been adjudged as an incompetent person makes any juristic act, okay, so that juristic act will become voidable. Okay, so now what happens if we have a person of unsound mind, but nobody brings any case before the court in order to adjudge him as an incompetent person. Okay, let's say that Mr. A, he is out of his mind. He is of unsound mind. He is so upset about something. Okay, let's say that maybe when Mr. A is so upset about the Prayut administration, because when he sees that Prayut is in power for so many years, and there is no progress in this country. Okay, no development in this country. The economy seems to be getting worse and worse and getting worse, and is turned from worst to worst. That is the perception by A. So he thinks about this every day. Okay, so that on a good day, his mind is what? His mind is just lost, totally lost. He just, he is just out of his own mind. Okay, his mind becomes unsound, and nobody just brings any application. Nobody just files an application to the court in order for the court to adjudge him as an incompetent person. But actually, his mind remains unsound. Okay, we call this one, okay, the person of defective unsound mind. Okay, คนวิกลจริตซึ่งไม่ได้ถูกศาลสั่งให้เป็นคนไร้ความสามารถ okay he is a person of the factor unsound mind. What happens? Does the law protect him? We have seen that if a person of unsound mind is adjudged by the court as an incompetent person, then the law, okay, protects him. The law places him under care of his guardian, okay, and the guardian will do everything for him. If he makes any juristic act, then that juristic act will simply become voidable. That is the protection by law given to a person of unsound mind who is adjudged by the court as an incompetent person. Okay, is there a similar protection? Is there a similar protection, okay, given to a person of the factor unsound mind? If a person of unsound mind who is not adjudged by the court as an incompetent person makes a juristic act at the time when his mind remains unsound, okay, does that juristic act carry any effect? Okay, in this case, the law, okay, that provides for protection in section 30. The law also protects that person. The juristic act, which is made by a person of the factor unsound mind, okay, will be voidable if the act was done at the time when his mind remained unsound and the other party also knew about his mental condition. The other party knew that the other party knew that that person of the factor unsound mind had the mind which remained unsound. Okay, so there are two conditions. The first one is that the act was done at a time when that person's mind remained unsound, and the second one is that the other party had a knowledge of such mental unsoundness. Okay, so now if we look at section 30, okay, you go to the wording of section 30 here. An act carried out by a person of unsound mind not yet adjudged by the court as an incompetent person is voidable. See, only when first, okay, it was carried out at the time when such person's mind remained unsound, and secondly, okay, the other party knew that the person carrying out the same means the juristic act, okay, was of unsound mind. So this is the protection given by law to a person of the factor unsound mind. Right. Now we are moving forward to discussing, the next case, the case of a quasi-incompetent person. Okay, quasi mean what? Quasi mean semi or half, not fully. Okay, เสมือน in Thai เสมือน okay. What happens when a quasi-incompetent person, okay, makes a juristic act? Okay, the quasi, Q-U-A-S-I, you may pronounce it as quasi or quasi. If you just resort to the British pronunciation, okay, you get quasi. If you just opt for an American way of pronunciation, you may pronounce it as quasi. Okay, well, this depends. Right. Now, right, the difference between a person of the difference between an incompetent person and a quasi-incompetent person is this. You can see that a person who is adjudged by the court as an incompetent, he is a person of unsound mind. His mind is absolutely unsound. He does not understand anything, so that the law places him under care of his guardian, and the law does not allow him to make any juristic act. the law just requires the guardian to do everything for him. But in the case of a person, in the case of a quasi and common person, it does not mean that his mind is unsound. His mind is still sound. He can understand things. But the thing is that even though he has ability to understand things, he has ability to digest things, right? But he is not able to manage his own affair. So if he manages his affair, then he will cause sort of prejudice to his own family or property. Right. The reason why he is unable to manage his own affair is because maybe he has some physical disability. Even though his mind is still sound, but he has some physical disabilities. He is maybe handicapped, so that it is very hard for him to manage his own affairs. Or maybe he has some mental infirmity. Okay. Just mental infirmity, but not being of unsound mind. His mind is still sound, but his mind is quite unstable. Sometimes he is okay, but sometimes he is not okay. Something like this, okay? Or maybe he is not able to manage his business because of what? Because of his habitual prodigality. He spend money too much every day, okay? Or maybe because of his debauchery, okay? The say play. I mean, prodigality is what? Surui surai, okay? So if he habitually behaves in a manner of prodigality or debauchery, okay? Or sometimes he is intoxicated too often. He drinks every day, okay? So, he drinks and he has to sleep in order to get over from his drunkenness, something like that, okay? Or any similar cause like this. The cause like this, if he is faced with this kind of situation, that means that this is obvious impediment to his management of his own affairs, so that the law should not just allow him to make some juristic acts. His mind is still sound. Okay, so the law said, well, because your mind is still sound, so we, the law, allow you to make juristic acts. But we have a list of certain juristic acts in respect of which this person is not allowed by law to make. Okay, because his mind is still sound, so the law said, fine, you can make juristic acts, except some juristic acts listed by law in section 34. So I think that the reason behind this restriction seems to be quite clear. Okay, a quasi and common person can just make juristic acts because his mind is still sound. Okay, but the law says that because of some factors which might constitute impediment to his management of business, if the transactions seem to be very important, the law does not want any harm, okay, to flow from his disability. Okay, the disability which is caused by the physical condition, mental condition, or prodigality, or debauchery, or intoxication, or the thing of that sort, so that if he enters into some juristic acts which are very, very important, the law does not want him to make alone. The law wants him to get consent from somebody who takes care of him. The person who takes care of him is called as a what? As the curator or entai pita. See? So I would like you to go to first, section 32, okay, which says something about, something about the quasi incompetent person. According to section 32, any person who has such physical disabilities or such mental infirmity or habitually behaves in a manner of such prodigality or debauchery, or becomes so intoxicated or has such other similar cause as to be unable to manage his own affairs, or as to manage affairs in a way likely to cause prejudice to his own property or family, may be adjudged by the court as a quasi incompetent person. So if you suffer this kind of this kind of thing, okay, this kind of the cause, physical disability, mental infirmity, okay, or habitual prodigality, debauchery, or intoxication, or a similar cause, then a person mentioned by law can just make an application to the court in order to adjudge, okay, the person as a quasi incompetent person, okay, and when he is a quasi incompetent person, the law does say something about the ability to make juristic acts, okay. If you look at paragraph 2 of the same section, the law says this: a person adjudged by the court as quasi the incompetent person under paragraph 1 shall be placed under curatorship. Okay, curatorship means curatorship, or in Thai, Quan Pitak. Okay. The appointment of a curator, Pu Pitak, see, shall be in accordance with provisions of Book 5 of this code. Okay, this section 32 says something about the status of a quasi incompetent person, and if we look at section 34, okay, section 34 say that a quasi incompetent person must obtain consent from his curator for doing the following acts. Okay, so this is the list of the acts. The list of the acts required by law to be made only upon consent of the curator. Okay, apart from the transactions listed in this section 34, okay, a quasi incompetent person may make juristic acts without consent from anybody, because he is well able, okay, to make. Those transactions may not be so important, so the law says, fine, we allow you to make those juristic acts. But if you make these juristic acts, the juristic acts listed in section 34, we regard these transactions as something of particular importance, so that if you are allowed by law to carry out these acts, you may run the risk of putting your affairs at loss, okay. You may run the risk of damaging or prejudicing your own affairs, so that we do not allow you to make these juristic acts. If you make these juristic acts, the important juristic acts listed in section 34, you need to get consent from your curator. Otherwise, the juristic act which is made by you will be voidable. Okay, now I don't think I'm going to just go through all the juristic acts listed in section 34, but I give you one example. Let's say that in subsection 8, doing any act for the purpose of acquiring or parting with a right in immovable property or vegetable movable property. Let's say that you want to sell your house. Of course, the house is so important. The house is something very important. If you are a quasi incompetent person, okay, if you are adjudged by the court as a quasi incompetent person, then If you want to sell your house, you may not do so by your own. Okay, you need to get consent from your curator, Pupitak. Otherwise, your sale will be voidable. Okay, this is when I say that if a quasi incompetent person makes this juristic act without consent from the curator, then that juristic act will be voidable. This is a consequence. Okay, this is a consequence flowing from section 34, paragraph 5. If you look at section 34, paragraph 5, it provides as follows: any act carried out in violation of the provisions of this section is voidable. See, meaning that if you make the juristic act, if you make any juristic act listed in section 34 without consent of your curator, okay, if you are a quasi incompetent person, then the juristic act in question will become what? Will become just voidable. Okay, so again, the consequences of voidability will be discussed later. Okay, not today, maybe in the next session. Okay. Okay, now 1 hour and 20 minutes. I think that fine. Okay, I may need to stop here. Okay, because I think that the next topic is causes of invalidity, which is something to do with the purpose or the objects of a juristic act. This seems to require a lot of explanation. Okay, remember, if you look at the list again, a juristic act may become invalid because of, first, the lack of legal capacity. The second one is the purpose or the object of a juristic act. The third one is the failure to comply with the form prescribed by law. Okay, and the last one is the impropriety or vitiation of will. Okay, I think that today we just talk about this one. Okay, next Monday, okay, we will just begin with our discussion of the objects, okay, or the purpose of a juristic act. There are some situations, okay, in which a juristic act in question has an object which is improper. The law does not want a juristic act to have an improper object, so that if a juristic act has an improper object, then it will be, by and large, it will be void. Okay, so that is something to be discussed next Monday. Okay, so I think that that's enough for today. Thank you very much for your attention. Okay, and I think that you are tired, and me too. I'm getting tired right now. Okay, so that I will see you again next Monday. Thank you. See you then. Bye bye.